The idea that someone's intelligence quotient could be legally adjusted based on whether they were intoxicated or had a history of heavy drinking seems counterintuitive. Yet, this is precisely what was argued in a Tennessee circuit court in a case involving two defendants, James Dellinger and Gary Sutton, both facing serious charges. The legal team contended that their client's functional intelligence was severely impacted by alcohol, potentially lowering their IQs below the statutory threshold for the death penalty.
That's right, Mia. This specific motion was filed in 1996 in Blount County, Tennessee, presided over by Judge D. Kelly Thomas, Jr. The defense for both Dellinger and Sutton essentially sought to have the court consider a reduced IQ score for their clients, arguing that long-term intoxication, or being under the influence at the time of the alleged crime, should factor into their mental capacity assessment for capital punishment eligibility.
So, the core of the argument revolves around the 70 IQ threshold for the death penalty, a critical benchmark. The defense brought in family members to establish a history of heavy drinking. Linda Dellinger, James's wife, testified that he had a practice of consuming large quantities of alcohol, sometimes a case of beer a day, particularly in the year leading up to his incarceration. She saw him on the day of the alleged offense, and in her opinion, he was quite intoxicated.
And her testimony indicated a long-term pattern, not just an isolated incident. She said Dellinger had been drinking heavily for years, especially the last full year before his arrest. She also mentioned he sustained a back injury around the time his heavy drinking started, and that on the specific date in question, she observed him to be significantly under the influence.
What about the expert testimony that was brought in to support this claim? Dr. Peter Young was the first expert called by the defense.
Dr. Young, a clinical psychologist, conducted a neuropsychological evaluation of James Dellinger. He used the Woodcock-Johnson test of cognitive ability, which yielded an IQ score of 72. He explained that since Dellinger had been tested with the Wechsler Adult Intelligence Test Revised, the WAIS-R, within the preceding 2 years, he opted for a different instrument. He clarified that the Woodcock-Johnson measures intelligence components, whereas the Wechsler scales often pull for general intelligence.
An IQ of 72 is very close to that critical 70-point threshold. What was Dr. Young's argument regarding this score and Dellinger's drinking history?
He argued that because Dellinger had been incarcerated and forced into sobriety for 3 years prior to his testing, his intellectual functioning would have improved. He stated that many people experience a rebound from the detrimental effects of alcohol on the brain, like shrinkage and decreased synaptic connections. Therefore, he believed Dellinger was likely functioning at a higher cognitive level when tested than he would have been at the time of the alleged crime when intoxicated. He said there's no doubt alcohol decreases functional IQ, citing studies on social drinkers showing impairment even 24 hours after consumption.
So, the defense was essentially asking the court to extrapolate backwards, to infer a lower IQ at the time of the crime. Did Dr. Young have a specific formula for this?
No, he admitted there's no specific formula to mathematically calculate that. He also acknowledged that very few studies have looked at people functioning while actually inebriated due to ethical standards, preventing researchers from getting people seriously intoxicated for testing. However, he maintained a strong probability that Dellinger's IQ would have been below 70 at the time of the crime.
The state's attorney then cross-examined Dr. Young. What was her approach?
She challenged his reliance on the scientific articles. For example, she pointed out that one of the articles he cited, Peterson et al., actually stated that alcohol intoxication did not produce deficits in verbal or general intelligence as measured by certain Wechsler subtests. She also noted that another article, Lishman, while discussing brain shrinkage, did not directly state that long-term intoxication increasing a person's IQ upon abstinence. She pressed him on the fact that there's no recognized statistical data to adjust IQ for an intoxicated state, to which Dr. Young concurred.
And the judge had some interesting questions for Dr. Young, particularly about the discrepancy between Dellinger's IQ scores.
Yes, the judge noted that Dellinger scored an 83 on the Wechsler in 1993, a year after the alleged crime and after he would have started sobriety, but then a 72 on the Woodcock-Johnson in 1995. He found this counterintuitive, expecting the score to go up further from alcohol if sobriety leads to improvement. Dr. Young attributed this difference to the tests themselves, explaining the Woodcock-Johnson's focus on intellectual components versus the Wechsler's emphasis on general intelligence. He also brought up the depressive effect of incarceration, which could pull intellectual functioning down, contrasting it with the pulling up effect of sobriety.
So we had similar testimony regarding Gary Sutton.
Precisely. Diane Sutton, Gary's sister-in-law, and Jimmy Sutton, his brother, both testified that Gary was a heavy daily drinker. Diane stated she almost never saw him without a drink in his hand for a year before his arrest. She also confirmed he was driving while intoxicated when he visited her home on the night of the alleged incident. The defense presented a psychological evaluation for Gary Sutton showing a full-scale IQ of 76 with an error factor of plus or minus 3, placing him in the borderline range. Dr. Young's opinion regarding the impact of alcohol on IQ would apply to Sutton as well, given similar drinking habits.
The state then called its own expert, Dr. Eugene Cord, a clinical psychologist. How did his testimony compare?
Dr. Cord was emphatic. He stated that the Wechsler scales are the most generally accepted measures of IQ and that he would never administer an IQ test to an intoxicated individual because the results would be invalid. Tests are standardized on sober populations, and results from an inebriated person couldn't be realistically interpreted. He confirmed there's no generally accepted statistical data to adjust an IQ score to reflect an intoxicated state.
Did he agree that alcohol can impair intellectual functioning?
He did, but he drew a crucial distinction. He stated that impairing performance is not the same as saying that one's IQ level has been altered. He argued that IQ, especially as measured by the Wechsler, is stable and doesn't tend to alter over time. He also pointed out that the articles cited by the defense, including the Page and Schaub article, explicitly state that no improvement was observed after 25 weeks of abstinence on intellectual functioning measures for alcoholics. This directly contradicted the defense's rebound theory as it pertains to actual IQ scores.
So Dr. Cord was saying that while a drunk person might perform poorly, their core IQ doesn't change.
Essentially, yes. He explained the concept of standard error of measurement in IQ tests, showing that for Sutton's 76 IQ, the true score would reliably fall between roughly 73 and 79. For Dellinger's 83 IQ, it would be around 80 to 86. In either case, using accepted scientific methods, neither defendant's IQ would reliably fall below 70. He also dismissed the idea that one could extrapolate a current IQ back to an intoxicated state years prior, as science does not tell us how far down the line it could be reduced.
This seems to highlight a fundamental disagreement in how legal and medical professionals define and measure intelligence in such a complex context.
Absolutely. The defense attorneys for both Dellinger and Sutton argued that if intellectual functioning is lowered by alcohol, then it must correlate to a lower IQ. They maintained that the tests used don't adequately measure the IQ of someone suffering from long-term alcoholism or brain damage, and therefore aren't valid for determining death penalty eligibility at the time of the offense.
And the state's counter-argument?
The state's attorney contended that the defense had failed to meet the burden of proof, specifically by not showing that either defendant's IQ was below 70 or that any mental retardation was manifested before age 18, both statutory requirements. She reiterated that there's no data to support adjusting IQ scores for intoxication, and that conflating cognitive impairment with an altered IQ level is scientifically unsound.
So what was the judge's final decision on this motion?
Judge Thomas denied the motion. He agreed that long-term alcohol addiction impairs intellectual functioning. However, he stated he was not convinced from the proof that that happens as a temporary lowering of a person's IQ. He focused on the three-pronged legal definition of mental retardation, which requires not just an IQ below 70, but also deficits in adaptive behavior and onset before age 18. He pointed out that Dellinger and Sutton were working individuals exhibiting adaptive behavior, and there was no proof of mental retardation manifesting before age 18. He concluded that the statute protects those who are mentally retarded since infancy or a very young age, not individuals whose intellectual position may have reached that intellectual position because of something that they did themselves.
An interesting distinction, upholding the legal definition over the functional implications of chronic alcohol abuse, in this specific context.
Indeed, it really underscores the complexity of applying psychological science to legal statutes, especially when those statutes have very specific definitions that may not fully align with all aspects of scientific understanding.
If you found this discussion thought-provoking, share it with someone who might also be interested.